Good evening to all the members who are attending to this webinar. We are having two young men, both are advocates, and they will discuss about the opportunities in GST and customs. I will introduce the first person. The first person is Parth Shah. He has 10 years of experience in the indirect taxes. Core area of experience is he has rich experience in assisting clients on various strategic and statutory issues pertaining to GST, customs, FTP, as well as STI laws of central excise, service tax, and VAT. He has led various projects relating to implementation of GST in India, obtaining export benefits, etc., for several large MNCs. He has assisted several clients in realignment of their supply chain to optimize the tax impact, guiding through assessments, providing litigation support, HS classification, customs and GST health check, etc. He is a chartered accountant and pursuing LLB now. And another person, another young man is Ashutosh Nath. He has completed CA and LLB, and he is having 15 years of experience. He has been advising clients on various customs and indirect tax issues across the sectors in India. He has managed hundreds of assignments, which include advisory and compliance related to special economic zone, free trade warehousing zone, free trade agreements, and excess classification and customs valuation, customs and trade health check, and indirect tax optimization, foreign trade policy including duty exemption schemes and credit scripts, GST implementation in India, and dispute resolution at various levels. Now it is over to CA Parth S. Shah. Then after some time, Ashutosh Nath will join. He will take for first 1.5 hours. Then Ashutosh Nath will take another 1.5 hours. We will complete at 8 o'clock. Over to our friend Parth S. Shah.
Thank you so much, sir, for such a nice introduction, and thank you to all the participants who have shown interest in this particular topic. I will quickly share my screen. So I hope the screen is visible, sir.
Yes, sir. Yes, sir.
Okay. Perfect. Okay, so the topic that both Ashutosh and I are going to discuss for next 3 hours is the opportunities and risk under customs, and customs, the area which according to us is a neglected child of a CFO. Now, the custom law itself is in existence since several decades, and the overall perception that most of us have about customs is that there are a lot of procedural strings which are attached to it, and which needs to be dealt on a daily basis. As a result, the practice across the industry has been that custom is something which is best suited to a person in a logistic or a operational department. Now the logistic guy per se is not expected to be a legal expert in the field of customs. In fact, their job even does not demand them to be so. If they are, then it's an add-on, nothing better. But otherwise, they are not supposed to have a lot of legal and technical knowledge about the custom law. They might be having a lot of procedural knowledge, which comes out of experience. But on the legal front, they do have to fall back on someone. Now, they are predominantly in regular touch with the CHS and the customs broker who are assisting them in getting the goods cleared. Maybe in the heat of the things or not knowing who else to get in touch with. It is often observed that the CHS acts as a quasi-consultant for the companies. Now CHA again is not expected to have a lot of legal knowledge about the custom law. They are no doubt they have a lot of procedural knowledge, but if we are relying on them for a legal matter or technical matters, then we are actually sitting on a big risk for the organization. Now now, if we know that customs is of course an indirect tax, and it is in fact one of the most complex and humongous indirect taxes. When I say humongous, it is because the sheer size of the law, the number of rules, the notifications, circulars which are issued under customs are much more than what we see under other indirect taxes, which makes the custom law extremely complicated. Even though it is very much part of indirect tax, it does not get a lot of attention of a CFO who, mind you, are completely hands-on with the income tax and the GST matters. And because it is slightly neglected by CFO, two things are happening. Number one, there are a lot of opportunities under customs which are trying to knock the door of the CFO. Now, because the CFO is not aware what kind of opportunities there on the other side, he's not able to identify, he's not opening the door, as a result of which they are missing on certain opportunities. And second point is the risk. Most often than not, what we have observed is that CFO eventually gets involved in a custom matter, but that involvement happens when the ship has already left the shore, and they are maybe they have a daunting task of addressing some kind of a litigation, some SCN or investigation. Now, mind you, if a CFO is getting involved at a litigation stage, litigation itself brings a big hit on that particular document for which a CFO is extremely possessive about. That is a financial statement. So through this session, we are attempting to talk about certain opportunities and risks which are available around this particular complex law called customs, and the discussion that we are going to have, the topics that we have covered are mainly coming out of the discussions that we had with some of our client personnel who are in the positions of a CFO and tax heads, and we really hope that through this session we are able to create some kind of awareness to get this neglected child a little closer to the CFO. The first opportunity that we would want to talk about is a free trade agreement. Now, a free trade agreement is a deal between two or more countries where both this country agree to reduce certain duty rates or give a upfront exemption on certain goods. And along with a tariff benefit via free trade agreement, they also try to give certain facilitation measures in the form of removing certain procedural barriers. Now, India has this free trade agreement or a preferential trade agreements with a lot of countries, including some of our neighboring countries like Sri Lanka, Nepal, Bangladesh, Indonesia, etc. Now, from company point of view, there are two broad benefits which are available under FTA. The first benefit is that FTA, if you are availing a benefit under FTA, it gives you opportunity to penetrate into the new market. And the second benefit is a duty related fiscal benefits. And we'll try to touch upon both these points. Now, the first one is the opportunity to penetrate into the new market. Now, I was recently reading one of the interviews of Niti Aayog CEO, Mr. Amitabh Kant, wherein he mentioned very specifically that FTA gives the Indian corporates a chance to be globally competitive, and it also gives them chance to penetrate into the new market, into the new territories. Now, this is not a statement which was generally given. The statement was actually backed up by certain statistics and numbers. Now, we have this agreement with South Asian countries called SAFTA. During the period from FY6 to FY19, the Indian export to these SAFTA countries was much more than the imports that we had from them. As a result of which, there was a significant increase in the trade surplus. Trade surplus is, of course, the value of export minus the value of import. And this trade surplus in the span of 12, 13 years had moved up from a $4 billion to a staggering $21 billion. Also, that there was some other statistics which indicated that after India has started signing various FTAs, the quantum of export that we have we are making to the new market, especially the developing and underdeveloped countries, is much more than what we used to export to, say, the likes of US and European Union a decade back. So now the situation is such that the quantum of export to the developing countries from India is much more than the one that we used to do to the developed countries. And this is just a proof that there are some companies who are actually availing the benefit of FTA. I'm minding my words when I say some countries, because there are only some companies, because there are only some companies who are taking this benefit, and not most or all companies. In fact, there was one survey which the result of which was that India's rate of FTA utilization is less than 25%. And if we have to compare this with some other developing and developed countries, the utilization is actually in the range of 70 to 75%, which means that, for example, if we have agreement with say Sri Lanka, so out of 100 people, or if 100 crore is the value of goods which is being exported to Sri Lanka, only 25% is under this FTA arrangement, and the other 75% is a normal trade without availing the benefit of FTA. And what this particular survey indicated, that one of the major reason why the companies are not availing the benefit under FTA is because of lack of awareness. And of course, a lack of awareness cannot be a reason to ignore the big benefits like this. And hence, when it comes to FTA, it is extremely essential that it is taken up as a management issue that needs to be addressed very strategically, and not merely a logistic or a operational issue. So this was about penetration into the market. There is one more benefit which is available under FTA, and that is a duty-related benefit. As I mentioned, that there are mainly two type of duty benefits which are available. One is that there is a ad hoc exemption on goods which are imported from the countries with whom we have a FTA, and vice versa. So when we export also, those goods would not be subjected to custom duty at the importing port. And also there are cases where there is a concessional rate of duty, and a couple of examples are the one that we have also provided in the slide. So that is this FTA that we have with Indonesia, wherein any goods under which are classifiable under heading 3822, that are diagnostic and laboratory reagents, the normal rate of duty for those goods ranges between 10% to 30%. However, if it is manufactured and imported from Indonesia, it's completely duty free. So it does make a lot of sense to avail the benefit under FTA. And similarly, there are benefits of concessional rate which are available if you're importing, like we have shown in our illustration too. Now, any kind of benefit under FTA have a direct impact on your profit and loss account. A lower duty which is levied on your imported goods will have a direct impact on the bottom line, which is a profit. And if there is a lower custom duty applicable to your customer whom you are exporting the goods, then it has a potential impact on your top line, because you will have this flexibility, or you would be in a position to play around with the pricing, because you know that there is a duty exemption which is available when you are sending goods to that particular customer who is based in a country with which India has a trade agreement. In fact, as I mentioned, that the tariff cost on business is so significant that it cannot be ignored. Now, if you look at this table that we have provided in the slide, and if you assume that a pre-tax profit of a company is 10% that of an import price, then a reduction of 3% tariff can have a same impact as a 30% reduction in corporate tax. Because in corporate tax, what we are trying to reduce is tax on profit, whereas in case of customs, what we are trying to reduce is a rate which is applicable on the goods that you're importing, which is the cost of goods. So share on the value terms, if you look at it, a 3% reduction in tariff will have same impact as 30% reduction in corporate tax. Now look at it from a CFO's point of view. CFO would pay a lot of attention to effectively structure his corporate tax. However, take a lot of opinions. He will do a lot of structuring. He would try to defer certain expenses and all that things. A lot of mind would be gone to save such a big corporate tax amount. But a similar benefit is also available under FTA, and these are the legitimate benefits and doesn't require any real structuring per se. And that is something which of course cannot be ignored and needs immediate attention. There is one more reason that why FTA related benefits should always be under the lens of a CFO. Now, under a FTA, importer or exporter, as the case may be, can claim a preferential tariff only on products that have a originating status. Now, this means that the benefit is available if the goods are made in the country of export. So, which means that if I'm exporting from India, I will be eligible or I will be eligible to claim FTA benefit only if goods are manufactured in India. And each FTA that we have with different countries or different group of countries have its own set of rules that lays down the criteria that needs to be fulfilled to attain this originating status. One of the criteria which is common in all the FTAs is regional value content, RVC. Now, what does RVC mean? RVC means that it's a minimum percentage of product's value that must originate in the country of export. Now, this particular, what it means is that if my value of goods is say 100 and RVC as per the FTA is say 35%, then value to the tune of 35 should at least consist of domestic items. And what does domestic item means? Domestic items would mean the material costs, the different overheads, etc. So if there is a trading account that we are preparing, so that is a gross profit which moves to profit and loss account. So in that trading account, the direct material costs and various overheads together would needs to be more than 35% to be eligible for a FTA benefit. So if you look at it, RVC has a lot of calculation which is required to be done and which has to be done very carefully. It cannot be done casually, because if done casually, there are you would be denied the benefit, and if identified post facto, you will be sitting on huge penal and interest consequences. Now, given that RVC consists of various elements of profit and loss account, finance-related expertise is required to oversight this particular calculation, and thus it is essential that somebody from CFO's office is involved when this computation of RVC is happening. And other point is that this RVC calculation varies from, as I mentioned, from FTA to FTA. For example, if a particular FTA is talking about 35% 35% RVC, and there is another country, say Korea, which is talking about RVC of 45%. Now, if a particular lot of goods are manufactured having a RVC of 38%, in order to avail the benefit, those goods have to be supplied to Bangladesh. If you have manufactured goods, they're lying in your warehouse, and there is an immediate demand that comes up from Korea, you would not be in a position to supply those lot of goods for on which RVC was 38% to Korea. And if you do that, you have to be careful of not availing this particular benefit. So this was on the RVC part. The other part of FTA is a need for proper interpretation of the agreement. Now, as we all know, and most of us are from the tax background or a legal background, that any statute or any law is required to be interpreted in a particular manner. There are different principles like a strict interpretation, a harmonious interpretation, liberal interpretation, etc. There are various types of interpretational clauses that are there, and that has to be applied looking at the language of that particular law. Now, in case of a FTA, now FTA per se is not a law. However, the principles of interpretation of statutes are equally applicable when we are reading a free trade agreement, because a minor misread or overread could actually lead to a delay or denial of benefit. And this again, we are talking out of experience that one of our client had actually misread one of the clauses which is there in the agreement, and because of which there was a delay in him being able to clear the goods from the port, and delay was for more than 2 months. So you can well imagine the amount of damage they would have paid just because they had not read the free trade agreement properly. And again, of course, if you have to pay damage for 2 months, it of course comes with a huge cost, and again having a financial impact. So this is a reason why free trade agreement is an extremely important opportunity, and it requires a lot of attention of CFO, and it's not something that should be ignored, and it is not something that one can simply overlook, because if you are overlooking, your competitors are very much trying to claim this benefit, and in order to stay in the market, you have to be up for it. The next set of benefit that I would like to discuss is with respect to authorized economic operator. Now, I will have a discussion, and I will divide the discussion into three parts. So the first part is what is authorized economic operator. The second is who are eligible to get this kind of certification, and third is what are the benefits which are available therein. The first question, what is AEO, authorized economic operator? Now, across the globe, the customs organization typically have two major challenges. First one is securing their borders from unlawful trades, which is smuggling, and simultaneously ensuring that the entire process is very smooth for a legitimate trader. And this particular concept, authorized economic operator, is an attempt made by the organization to achieve these two objectives. Now, AEO itself is a concept which took birth from SAFE, Safe Framework of World Custom Organization, and is adopted by several countries. Now, AEO is a certification that you receive from customs, and this certification is like a quality mark which certifies that your processes in relation to customs and various safety and security are properly in place. And if you have a AEO certification, then from customs point of view or from a global supply chain point of view, you are treated as a trusted partner. Now, globally, as I mentioned, that AEO is a concept which has been adopted globally. AEO certification is gradually evolving in the industry at a global level, and as I mentioned, it is seen as a standard for claiming any kind of a benefit which is offered by government, certain discretionary benefits which are being offered by government. Now, AEO program in India is administered by CBIC, Central Board of Indirect Tax and Customs, and it was started long time back, and the program did not attract a lot of companies in the beginning, and thus it was relaunched in 2016 wide circular number 33 by 2016, and it attempted to provide various additional facilities. Now, while response to AEO 2.0 was much better, there still exists a lot of awareness about it, because of which there are companies which are staying away from the real and tangible benefits that AEO offers, and the benefits that AEO offers is something that we have put in this particular slide. Now, the benefits are basically of two types. Or we can divide the benefits into two parts. So one is the finance related benefits, and the second is logistic related benefits. Now, if you look at the finance related benefit, the first one is payment of duty. Now, unlike a GST or income tax, customs is not a tax which is paid on a periodic basis. In fact, custom duty is required to be paid before the goods are cleared for home consumption, which means that there is a direct linking between the clearance of goods and payment of duty. Until the time you don't pay the duty, you're not allowed to remove the goods from the port. Now, AEO, what AEO does is that it is delinking this particular process. It is delinking the clearance with the payment of duty, and like GST and income tax, it is trying to bring a periodic payment for custom duty, which means that if somebody has obtained a AEO certificate, he has only 2 days per month to pay customs duty. So if his bill of entry is dated somewhere between the 1st to 15th of the month, then the due date for payment of duty would be 16th of that month. And if the bill of entry is dated between 16th and 31st, the due date for payment of duty would be 1st of the following month. So a very important benefit, because this has a direct impact on the working capital of the company. Instead of paying duty on a daily basis, you are in a position to defer it by 15 days. So this has significant impact on your working capital. The other financial related and related benefit that we would want to talk about is a direct port delivery. Now, while direct port delivery may look like a logistic related benefit, but it also has a significant portion of financial benefit. Now, presently, when we import goods, it may take some time for it to get cleared while our truck is waiting at a port, ready to get loaded. But there could be a long queue, and you're waiting somewhere in the queue, which is taking a lot of time. There could be certain verification which is been going on by the appraising officer, or your goods have been picked up in the RMS, the risk based assessment that customs have. Now, this is something that happens to a regular importer, because he will have to factor in some time, and that some time may vary from 1 day to say even 5 to 7 days. He will have to factor that time when he has imported the goods. But if you are a AEO certificate holder, you will get the benefit of direct port delivery, which means that you will get a priority over all other importers. So which means if there is a queue, you can cut the queue. You will be the person who will be given that priority, will be the person whose verification will be done before anyone else, and your goods will be allowed to be delivered directly from the port, which means that there is a significant amount of financial saving, because normally what happens is that when you import the goods, you have to move the goods to a custom freight station, and when goods are lying at a custom freight station, there are significant amount of cost which a company has to incur. You will be saving on that particular cost. Also, what happens at the custom freight station is that there is an appraising officer waiting for assessing the goods, and I will give you one example of what had happened to one of our client. They had imported certain medicinal material which was supposed to be kept in a controlled temperature. Now, of course, that particular station did not have a facility to take care of a particular temperature which was required for that set of goods. Appraising officer had decided to open the container and conduct verification, and because of that, the complete material, the all the goods which were lying in that particular box were completely damaged, because the integrity of temperature was being breached. And as unfortunate as it may look like, but it had a significant amount of financial cost for the company. To add to it, because material were damaged, they were not used for the further manufacturing and processing, resulting in some other losses. Now, other than this saving of CFS charges, a direct port delivery also gives you an opportunity to restructure your procurement policy. So, for example, if you have considered a delay of 2 days, or if you consider that your goods will be lying at a port for 2 days before it can be used for the manufacturing process, if your AO holder, that 2 days would get reduced to few hours. Accordingly, your entire procurement process can be revisited, and which again indirectly will have a working capital, because you are getting goods 2 days in advance, or you may delay your order by 2 days, which again have a working capital impact. The The other financial benefit which is available available for the AEO is a bank guarantee waiver. Now, as we know that when we import certain goods and there is a disconnect between the duty which is payable by the importer and the customs authority, uh, the importer always have an option to clear the goods by furnishing a bank guarantee. Now, and bank guarantee more often than not is equal to the duty amount. Now, under AEO, there is a concession or a waiver of bank guarantee which is provided to his certificate holder. Now, depending on the type of AEO certification that you have, there are actually three types: T1, T2, T3. Depending on the type of certificate that you have, you will get a bank guarantee waiver, which could be say either 50%, 75%, or even a complete waiver, which again have a decent amount of financial impact. The next set of benefits which are given to AEO is, as I mentioned, there are a lot of priorities. So be it your refund claims, your drawbacks, your SVB assessment, etc. You are given priority. All your cases, even different indirect tax cases which are lying before the jurisdictional officers, all of them are taken on priority. And because they are taken on priority, you will achieve a closer at a much faster rate, which again has, of course, the financial benefit attached to it. So other than those financial benefits, there are also certain logistic related benefits. Of course, direct boat delivery is one that we mentioned. There are priority that you get in processing of documents like your bill of entry, shipping bill, etc. There is a complete paperless exchange of information. You're not required to submit a hard copy of any documents. Things in electronic form is completely acceptable, because and the reason why it is acceptable is that the authority trust a importer who is having a AO certification, and this entire scheme is based out of trust. The fact that they are allowing you a deferral of duty, they are allowing you to clear the goods without any verification, etc. There is a lot of trust that they put on a AO certificate holder, and as a result of which, the the good point about that trust is that you are getting a lot of fiscal and tangible benefits. Now, if we talk about this tangible benefits, we have tried to give a illustration in this particular slide. Now, if we say that we have an import of say around 100 crore per month, then potentially we can save around one crore of working capital by just being a AO certificate holder. So assuming that you are importing goods on 16th of every month, instead of paying on 16, you will be paying on the first of next month, so that the 15 days benefit for entire year could lead to a benefit of over 1 crore. And that is something which is not worth missing, because you don't have to do anything extra. You don't have to take any efforts, go out of the way. You just have to ensure that your processes are in place, your safety and security measures are in line with what customs wants, and you would be entitled to this particular benefit. The other one that we talked about, the just-in-time procurement policy. If you are a AEO, because of the direct port delivery benefit, you will be able to uh, uh, adjust your procurement policy, resulting in fiscal policies. And given that there are so many fiscal policies available, this is something that should should get a lot of attention and should be opportunity worth grabbing. The export benefits. Now, in this particular slides, we have tried to touch upon the various export benefits which are available to a company, be it in the form of MES, SEIS, EPCG scheme, then EOU, STP, road dep, which got notified very recently, advance authorization. Now, all these schemes are, basis of experience you're speaking, they are very much under the lens of a CFO and the tax heads. They are aware about the scheme, and they are continuously taking benefit under the scheme. Now, one particular scheme that we would want to talk about, which lacks enough attention, is duty drawback. Now, And more particularly, we are going to talk about one particular type of duty drawback. Now, what is duty drawback? Uh, it is a known fact that many governments across the globe try to refund all the taxes which are paid by the exporter so that the product which is being exported remains competitive in the international market. Now, the age-old saying that you can export the goods, but you cannot export the taxes. And that's the reason why a lot of governments reimburse the tax component which is levied on the value of exported goods. China is in fact one of the biggest example as to how a government incentives can actually do wonders to the entire export sector. Now this process of refunding the taxes which is involved in manufacturing of the exported goods is called a drawback. Now in India, the drawback is remission of import duties which is levied on imports and which are used for manufacture of goods which are eventually exported. Now there are two types of duty drawbacks. One is based out of AIR, that is All India Rate, and this is the most popular one. And the reason why it is so popular is because amongst all the export related benefits that we talked about in the previous slide, this particular AIR duty drawback has a potential to be a perfect brand ambassador for ease of doing business. Getting a duty drawback under AIR is extremely simple, and it's the benefit will be you will get by clicking the right buttons while filing shipping bill. It's that simple. Now, AIR is basically average rate which is based on average volume of inputs which goes in manufacturing output. So it's basically average rate, and this average has been computed by the ministry taking various inputs from trade and industry. Now, any person who is claiming this EIR benefit will always have one common complaint, and that complaint is that the EIR rates are way too low. They are not in line with the market reality, and they do not compensate the actual duty which is suffered on the inputs which are used to manufacture goods. But still, they stick around with this particular EIR because of the procedural comfort. The other duty drawback is the brand rate. The provision of brand rate itself indicates that it is for those exporters who considers that EIR rate is not sufficient to fully neutralize the duty which is suffered on inputs. Thus, the brand rate actually tries to very clearly address the concern that most of the people who are availing the EIR rate are having. However, this brand rate is not at all popular, and probably there are two reasons to it. One is that it is that is one reason is that of course lack of awareness, and second reason is the process of claiming this particular drawback is extremely cumbersome and is slightly complex. No, as I mentioned earlier, that a EIR rate is more like an average rate, and brand rate is more of a actual rate. Because in brand rate, what happens is that we would be giving details of how much duty we have suffered in manufacturing the export goods, and we'll try to get refund of that entire duty component. So brand rate is more of actual rate, and EIR is more of a average rate. So in other words, AIR can be said to be one size that fits all, if we have to put it in simple terms. But this one size fits all can be applicable for companies who are having a simple manufacturing process because it is those industries whose data has been picked up by the government in determining this EIR rate. But the companies who have complex manufacturing processes, who have different engineering companies, etc., for them EIR rate is not going to give full justification. And if you look at this particular illustration, this is for a automobile manufacturing company. Now the EIR rate for the automobile manufacturer varies between range of 2% to 4%, and the rate varies depending on the size of the vehicle and size of the engine. Now this is the EIR rate, and if we have to do the brand rate, if we do the computation, the brand rate comes up to somewhere between 4 to 6.5%. Thus, there is a 2% impact on the benefit that you can claim. So if you assume that this particular manufacturer is exporting a cars of value say 500 crore, the differential duty drawback that one can get is as big as 10 crores. Now 10 crore is of course a very big number, and such benefit cannot be ignored just because procedures are cumbersome or they are complex. Now, in fact, if you look at it from a CFO's point of view, all decisions that a CFO takes, not just tax related, but any decision that he takes for the company, are on the basis of cost benefit analysis. So here, if this manufacturer who has an export of say 500 crore, if CFO of that company has to do cost benefit analysis, the benefit is 10 crore rupees. And what is the cost? The cost is the amount of pain that will go in the entire process, which is cumbersome and complex. Now, if we have to compare, the benefit of 10 crore is much more than the pain that one has to suffer. And in any way, say if there is a pain in claiming branded, that you have the experts, consultant, etc., whom you can outsource. Uh, and in fact, one of the CFO that we were recently discussing with, he had recently moved from the EIR to the brand rate, and he also fortified the same thing that I'm mentioning, that what he said, that understood the process is complicated, but we still prefer because of the kind of financial benefits that brand rate is bringing on the table. And after all, it's a process. If it is understood, if we know what kind of data is to be given, then things can move at an autopilot mode from the second year onwards. You just need to work on the processes, you have to put efforts in getting the process right, and once it's done, you will keep on getting benefits very smoothly. In fact, let me attempt to touch upon the process that goes in getting the benefit under the brand rate of duty drawback. Now, uh, if I have to put it in very simple terms, the steps that are required, if you look at it in this particular slide, also 1, 2, 3, 4, the steps which are required are somewhat similar to the steps that we take while claiming the benefit under benefit for service tax refund. So that is collation of data, that is converting that data into a proper format, submitting that particular documents to the jurisdiction officer, licensing with the authority. If he has any questions which comes up during the verification, give those answers to those questions. If he requires any further information, furnish him that information, and once he's satisfied with the documents you have provided, you are given the benefits. So if you look at steps, and of course this has been captured in very simple terms, the steps which are required to be followed for getting a duty drawback is similar to the steps that we take in claiming any kind of benefit. Of course, the under each step, the amount of work that needs to be done is much more, which makes this a little complex one. But if you look at the first part, and which is collation of documents, and this is the part where maximum efforts go. The kind of information which is required is say data required for consumption, data required which demonstrate that what is the duty component which was levied on various inputs which are used in manufacturing goods which are being exported. Now this all are purely financial numbers. Now given the state of art we have in the technology, all this data should ideally be a couple of clicks away. And in fact that there are a lot of tools which are also available for the company to gather such information from the ERP system. And getting this data could be a easy task or may not look very complex if it is being handled by the right person. So which means that if you ask somebody in the CFO's office to give details of consumption data, or the component of duty which a particular input has suffered, he would be able to give it immediately. But if you expect a logistic guy or operational guy to collate this data and prepare various documents in the formats which law has provided, he will surely have a nightmare. And it is because of this, because it is not handled by the right person in CFO's office. This entire process looks cumbersome. This entire process looks like pain. Thus, to summarize, process might be complex, but we have to look beyond the procedural challenges and claim the benefit to which we are entitled and to which we are eligible. And as I gave in the example, the benefit of say a 10 crore is not worth missing just because the processes are complex. The next point that I would want to talk about is certain special warehouses. These are manufacturing activity to which is allowed in a custom bonded warehouse, and a trading activity which is allowed in a free trade warehouse. Now these are a couple of areas which are again gives a lot of fiscal benefits, but they are for some reason are yet to become popular. The popularity is picking up, but it is yet to become very popular. There are still companies who should be looking to restructure their arrangement, their storage and warehousing facilities. They should consider moving to manufacturing under custom bonded warehouse to have a lot of financial benefits. And again, the same reason as you mentioned in the previous slide. The reason why the schemes are not very popular is because there is a lack of awareness amongst the right decision makers. Now, let me talk about the custom bonded warehouse first. Custom bonded warehouse is a facility which is available in which your imported goods are allowed to be stored under a customs control, and it happens in a designated place or a warehouse. And when I say designated place, it can be any place. It doesn't, unlike say a SEZ or something, it doesn't have to be in a particular area. Any particular area which you believe where you want to conduct this manufacturing activity under the supervision of a custom authority, under the control of custom authority, can become a custom bonded warehouse. So what this particular facility is saying is that it allows you to defer the custom duty payment at a later stage. So which means if you are bringing goods into this custom bonded warehouse, you do not have to pay the custom duty upfront. You can defer this payment of custom duty, and as we have also given in this particular illustration. So what happens is that for this manufacturing and the custom bonded warehouse, there was this particular benefit which or particular scheme which government had introduced in October 2019, which is known as manufacturing and other operations in bonded warehouse scheme. Now, what this scheme is saying is that the scheme facilitates import of various inputs and capital goods without payment of duty for manufacturing and manufacturing related operations in a bonded manufacturing facility. Now, what it is saying is that you bring goods without payment of custom duty, you store it in this particular warehouse, you perform manufacturing activities on it, and after you have manufactured the goods, if you are going to export it back out of India, then you are not required to pay any custom duty because goods have ultimately not been cleared for home consumption. There is no custom duty which is required to be payable. If the goods that you have manufactured in this warehouse are not cleared to or not exported, they are actually supplied to a person in a DTA, domestic tariff area. It is at that stage that you are required to pay custom duty, and this custom duty is to be paid without any interest, which means that let us take an example that I am performing a manufacturing activity, and the goods that I've manufactured are a part of it is exported and a part of it is supplied to my domestic customers. Now what will happen is that as soon as I import the goods, I would be required to pay customs duty. And of course, as we all know, that custom duty is a huge cost, could be 30%, 40% also. So I have to upfront pay the custom duty, perform the manufacturing activity. if I clear the goods as it is in, I was required to pay custom duty and I've paid custom duty. But if I export the goods, what will happen is that if I export the goods, I will try to claim different export benefits which are available. Say something like a duty drawback. I will try to see what is the custom duty that I've suffered, and on the basis of that, I will try to see which is the best export benefit which is available to me, and I will try to claim that. This is what will happen if you are undertaking this activity in a normal warehouse, which is not a custom bonded. Now compare it with a custom bonded warehouse. You are not paying any custom duty upfront. You have, say you have bought the goods on first. You are conducting manufacturing activity. That activity took almost 1 month, and now you are supplying it to a person located in a domestic tariff area. It is at this stage where you are paying custom duty. So a custom duty which was otherwise required to be paid on first is now being paid on 30th. As a result, that is a deferment of customs duty, which results in less blockage of funds and a significant working capital impact. Second benefit is that when you are trying to claim export benefits, it's going to be stress free. You don't have to stress about various conditions which might be attached to the export benefits, like actual user condition or actual export obligation, etc. You can simply export it without any headache. So this is one particular scheme which is picking up. We have seen and we have implemented a lot of shift for some of the clients, wherein they have moved from the normal warehouse to this manufacturing custom bonded warehouse. The scheme is picking up, but if somebody is not aware about, and if he feels that this is a benefit worth exploring, he should definitely do one.
So it is
Similar,
like IC sales transaction, no?
So it could be a high C sales as well. So in fact, if you talk about a free trade warehouse also, so what happens in a free trade zone is that here in free trades in free trade warehouse, it's not a manufacturing facility which is allowed, but there are a lot of other activities like trading, warehousing, and certain packaging, etc., which is being allowed to FTWZ. Now the reason why FTWZ was introduced was to make India as a global trading hub by creating the infrastructures and providing different facilities to various people who wants to do a high C sale. If goods are coming, they may come, they may import it and bring it on in FTWZ. They may perform certain activities like packing, repacking, etc. And then from India, it may get shipped to the ultimate country of ultimate destination. So even FTWZ provides a similar kind of benefit that when you are clearing the goods from the port and bringing it to into FTWZ, you're not required to pay any duty. In fact, FTWZ is a special economic zone itself. It's a subset of a SEZ. So any benefits which are available to a SEZ will by de facto be available to a FTWZ as well. And because as we know that SEZ is deemed to be a territory outside India, so would be FTWZ. So when we are bringing goods from port to FTWZ, we are not required to pay any custom duty. So this benefit of deferral duty and not bothering about the conditions which are attached to the export benefits, be it a duty drawback or EPCT, etc. One may not have to worry if goods are brought into FTWZ. The difference is that if goods are cleared from FTWZ for home consumption, then unlike manufacturing warehouse where there is no interest element, in case of FTWZ, there would be an interest element for the custom duty that you have deferred. But having said so, if not for domestic, for goods which are imported for the purpose of export, this is a benefit which is definitely worth exploring, and conducting this trading activity of importing and exporting in DTA just doesn't make sense when you have two such a lovely and special warehousing facility which is given by the government. So again, the benefits are tangible. The benefits are not explored by many, and one of the reason why it is not explored is is lack of proper awareness. And thus again, like to reemphasize that the right set of people need to be aware about such schemes so that the right benefits are being taken by the company. Uh, the next set of slide is certain non-traditional refunds. Now, when we say refund, our the first thing that will come to our mind is a IGST refund, which is available to a exporter under Section 16 of IGST Act. It's the most popular set of refund that every exporter claims. Even before the arrival of GST, exporter was eligible to claim a refund of Senvet credit under Rule 18 and 19 of Central Excise Rules. So this is more of a traditional refund which is available when goods are exported out of India. But there are certain type of refund which arises because there is some excess duty that you have paid on your import side. Now, again, a disclaimer: these are completely exceptional refund. This may not arise very regularly, but we are discussing because the refunds are available. We just want to create this awareness that refunds are available, and it doesn't make sense to wear a blinder or close your eyes and completely ignore this particular set of benefits. Now, let me give you a couple of examples that we are handling where a refund under on the import side had come up. Now, when we file a bill of entry, it's a self-assessment that takes place, and it is based on self declaration. Now, which means that in case of self-assessment of bill of entry, it is very imperative that the importer mentions all the details correctly in the bill of entry. Now what we had observed for one of the cases that there was some exemption notification, some exemption benefits which were available to that particular importer. Again, it was a temporary exemption because the product which were being imported were in relation to medicinal use, and it had some benefits which were attached to COVID. So during the first wave of COVID and again during the second wave of COVID, custom authorities had come up with several exemptions for products which were directly or indirectly used for curing patients and on account of COVID. So there were this exemption notifications which were being available, but the person filing bill of entry was completely unaware about it, and he only got to know post facto that there were benefits which were available, which he had missed claiming while filing bill of entry. Now, the customs law provides the facility of amending your bill of entry, and it allows you to amend the bill of entry, and after amending, if it is established that there is excess duty that you have paid, those duty are required to be refunded to you. So again, the point that I'm trying to make is that there are refunds which are, of course, on an exceptional basis, which are available on the import side. Now, how did this refund came to the notice of this particular client? The person at the ground level, because as I mentioned, he was more of an operational guy who was not aware, or he's not regularly updated about the the notifications which are being issued by CBIC, and it came to his notice only after it was highlighted by us, and we had highlighted it through their CFO, who in turn told the logistic guy to initiate a process of amendment. So because they are not a set of people who would be looking at the notifications which are issued on a regular basis, they might miss out on benefits like this which are available to the company. Now, there is one more benefit on the import side, again a non-traditional one, and it's actually very interesting one because this is based on a recent High Court ruling in the case of Sony India Private Limited, and this case law was reported a couple of weeks back. Sorry. Now, this case law again is a classic example which demonstrate that a company was able to get refund because of its awareness of various judicial ruling, especially that of Supreme Court ruling, and knowing that case law, reading that case law, and linking that case law to his own case helped him get helped Sony get significant amount of refund. Now, I will just spend couple of minutes to explain what that case law was. Now, what had happened is that Sony had imported a mobile phone in FY15. Uh, Under excise, there was a concession rate of duty which was applicable on mobile if no credit of input is taken to manufacture that mobile phone. Now, and the concession rate which was available was 1% of excise duty, vis-a-vis 6% duty which was otherwise levied on mobile phones. Now, authority did not allow exemption or this concession rate to Sony by pointing out that if you look at the condition says that you're not supposed to avail the SENVET and it should not be used for manufacturing. So it is more of a benefit which is available to a manufacturer in India. Because the mobile phones are not manufactured in India, you are simply trading. The goods are actually manufactured outside India. You're not allowed to claim this particular benefit. Now, what had happened is that in FY16, so this import had happened in 14-15. In FY16, there was a Supreme Court ruling in case of SRF, wherein they had actually interpreted this particular concessional benefit which is available in a notification, and they pronounced that the benefit is not only restricted to a manufacturer, it's not only a excise related benefit, but it is also CVD, countervailing duty back then, CVD related benefit. Then importer trader is also allowed to clear mobile phones for 1% duty. So this ruling came in 2016. Thereafter, after 2 years, that is in 18-19, there was one more ruling which came, again a Supreme Court ruling in case of ITC, which suggested that there was no time limit which was available for filing a amendment application. So what happened is that Sony, who had imported goods in FY15, actually filed a amendment application in FY19 after more than 4.5 years, and of course the lower authorities were not in a position to appreciate what was suggested by Supreme Court. So the matter had reached the High Court, and High Court confirmed that even if this application was filed after 4.5 years, even if it was filed on the basis of a Supreme Court ruling that had been pronounced after Sony had imported the goods, even in that case, Sony is eligible to claim the refund. Now, if, for example, if in case of Sony, if the custom matter was handled by a logistic or an operational guy who did not have a lot of idea about the ruling of SRF or the ruling of IT which was being pronounced, then Sony would have surely missed out on this particular benefit. Now, because the right set of people who knew the law had read the ruling, they were able to link it with some import that had taken few years back, and they were able to get lot of benefits, lot of refund for their company. So the point that we are trying to make is that customs, after all, is a indirect tax. So the amount of efforts that a person makes in GST, where he is reading the circulars, notification, regularly keeping himself updated with the case law, a similar kind of efforts is also demanded by customs, and customs is right to demand such attention and such efforts, because it has a potential to offer you benefits which could be much more than what the income tax or a GST law is giving. And thus to conclude, to summarize what I've mentioned, that customs, even though is a neglected child of a CFO, it is important that it is adopted. It is adopted as early as it can, because as I mentioned earlier, that there are a lot of opportunities which are knocking the door, and it's important that you open the door and grab the opportunities before it's too late. And with that, I would like to hand it over to my co-speaker, Mr. Ashutosh Nath, to discuss about various risks which are there under customs. Over to you, Ashutosh.
Thanks a lot, Parth. Mr. Murli, are you trying to speak something? Because we can't hear you. You must be on mute.
Unmute yourself, sir, please.
Yeah.
Yeah, now you can speak, sir.
Yes, yes. Parth Shah was given the opportunities under Customs Act. Now it is over to Ashutosh Nath for taking the risk.
Right, right. So thanks a lot. Thanks a lot.
Thank you, sir.
In fact, Parth did provide about a lot of information on how a company can actually benefit by actually utilizing the potential that customs law offers. Right. One of the examples that that Parth did show to us was that, you know, assuming that your profit is approximately 10% in the range of 10%, then the amount of saving that you can do, or you know, the cash flow that you can improve by reducing the duty impact only by 3% is equivalent to the 30% of income tax saving. Okay. So I mean, this is really a big deal. I mean, you know, this has to be looked in from this perspective. Okay, and therefore, when we were talking about this topic and we decided that we go for it and we speak for this topic, we thought a lot about, you know, about how it is being handled on the ground. You know, what are the experiences that we are having in the day-to-day course, right? And therefore, one of the points that you know, I'll request all the listeners here is that you know, many of the things that we are speaking here, especially in a risk case, will be based on the experiences that we have gained over a period, I mean, of extensively working into this field. So, you know, before completely focusing into customs, I was you know, when working with another big four consultancy firm, I mean, the focus was in GST, but that's where I spotted that, you know, that there is a that there are not much of the CAs and the advocates who can actually, you know, read the law, interpret the law, and then, you know, bring the value out of the legislation. Okay, and therefore, you know, anything that we speak is out of experience. So, you know, wherever all of you, you know, if you have questions, or if your experience is different than what we are speaking of, kindly come up and please share. You know, let's make it as interactive as we can make it. Yeah. So first thing first, I must say that, you know, of the hundreds of companies that you know, I have participated in reviewing them, and of the lot of people that I have talked to, one thing, and I can say this with a lot of authority, is that there are hardly any company, okay, which is actually claiming all the benefits which are available under the Customs Act. That's one. And second, more importantly, is that there are hardly any companies which are fully compliant under customs. So the benefit is also not being claimed, and at the same time, there is a lack of compliance also on the part of customs. Now, one is the experience that I said, that, you know, we have reviewed the hundreds of the companies, and then I'm speaking like an authority on this point. But, you know, I can back this up with one of the data which was published by the government when they revised the AEO program that Parth talked about, the Authorized Economic Operator program. is where government published that they intend to improve the compliances under customs. And one of the objectives of the AU program, I mean, this is also called as a trusted trader program in other countries, where the government is trying to enhance the trust between the importer and the government authorities. Okay, so one of the points that they highlighted, and it was their observation that 85% of the companies, I mean, they had written more than 80% of the companies in India under customs are actually non-compliant. Right. So this is one thing which has been noted by the authorities themselves. Right. Nonetheless, the push is there. I mean, we see the AU program where once you apply for the AU program, you have to submit a lot of the standard operating procedures as to how are you managing your finances, how are the business operations, right? So that the government is aware that you are a good company, you are a compliant company. Okay, you care for the legislation which is there. You want to abide by the rules and the regulations. You have a good practice in place, and therefore you are granted this status. Like one of the advantages that Parth said that once you are granted this status, then unlike the general importers where you have to pay the duty on the time of importation itself when you clear the shipment, in case of an AEO, you have the option of paying the duty after 15 days. Right now, this is a big deal. I mean, try to understand it from the point of customs, where the collection of duty per month is in excess of 25-30,000 crore, right? And to that they are ready to grant you an extension of 15 days. Okay, so thinking from their point of view, okay, this is a big thing that they're offering, right? But what they are looking for, they are looking for you to be more compliant, okay, more focused towards your operations, more focused toward your finances, the way you recruit people in the team, what kind of a person you're hiring, who is looking after say a classification or the valuation issues. So these all things are examined before you get the certification. So government is also moving in the right direction. And more importantly, now, I mean, this is again out of experience, is that most of the companies have also started focusing upon the compliance and the customs, because so far it was like just being handled, and if any issue comes up, people pick up, but otherwise it's of no importance as such. So having mentioned this, let us see some of the risks which are being posed under this act, right? And how does or where does this lead to? Parth will move to the next slide. Yeah. So that just complete this, no? Correct. Now, what is the objective of putting this slide is actually not to scare you. The idea is that we want to highlight, okay, is that the consequences of a company not being compliant, a company evading the duty or not paying the right sort of duties, not having the appropriate licenses in place. Okay, so for those sort of problems, okay, we note that day in and day out the people are getting notices, are getting arrested. Okay, and what's of the most importance here, which is what we want to highlight, and that is where the linking of the topic is an ignored child of a CFO, is that you see, I mean, one of the news here you read Economic Times. Here it says DRI arrests future enterprises CFO for evasion of customs duty. So mind you, let us not forget that, I mean, for our own convenience, we say that let this be handled by somebody. Okay, but fact of the matter is that customs is governed by a law. It's governed by Customs Act 1962. and there are the provisions are very much like you read in the income tax, you read in the GST. Okay, so you have to interpret things up, understand how the implications can be. Okay, and then decide about the processes that you have in the company, or what are the next steps that you want to take. Nonetheless, for the defaults that happen within the company or any sort of evasions, the experience is that in more than 50% of the cases, it is the CFO or the finance controller which is picked, who is picked up. I mean, in one of the news that you see here, firm's MD also gets arrested for evading the customs duty. Okay, so what we're trying to highlight is that you just say that, okay, this is the domain of the logistics and let them handle, but at the end of the day you are being investigated for the deed of somebody else, right? Do you actually want to do you actually want that to happen? Because you were not aware, you get to know about it only when you see the notice, only when you get a call, or the authorities are at your door, okay, saying that you have evaded the duty, and you come to know only through the authority. You have no visibility of what is happening. Okay, now that is one thing that we essentially wanted to question. Okay, because uh, like I mentioned, you get into the trouble, you get into a problem for the act of somebody else. Now that somebody else is, of course, a person within the company who is managing the operations. Okay, and you at the finance, the tax team, okay, or we the chartered accountant families who generally are sitting within that finance role and the tax role. Okay, did not pay a lot of attention to customs, right? Now, only for the sake of reiteration, okay, I must say that this is an act. Okay, this is the law. There is no operational procedure that it's just an operation, and anything that happens through the operation becomes a standard operating mechanism. This is a legislation. This needs interpretation. And if I have to share my experience again, it's 80% interpretation and the mechanism, the planning, and only 20% related to operations. And the idea again behind talking is that for us, the chartered accountants, the finance professionals, like it's important that we take note of this. We also take responsibility of this. Okay, because we get into a problem, so might as well we know the problem beforehand as to what is coming in. Just to the next slide, Parth. Right. So while actually talking about the risk, and when we were researching while doing this presentation also, or some of the cases that we handle, what we just thought that we first of all highlight the arrest and the personal penalties. Okay. Now there is an objective behind writing the word personal penalty, because in case of a company, it is essentially the directors, the important persons, the management personnel, the authorized signatory, okay, who get arrested, because company per se has no existence. I mean, technically it has, legally it has, but then practically speaking, an income tax person or a customs or a GST authority cannot come and say that, okay, let's catch hold of A Limited. There has to be a director of A Limited. There has to be a CFO or supply chain head, anybody of A Limited. Okay. So and that was the objective behind we picking up the arrest and the personal penalty provision, for all of us to be aware that something that the finance team is not aware, something that the CFO is not aware, okay, and where it can lead to. So needless to mention, in cases of offenses, there are two set of offenses. One is a cognizable offense, and second is a non-cognizable offense. Cognizable offenses are, of course, more serious in nature compared to non-cognizable. Now, we are not discussing criminology here, where we talk about some heinous crimes. In our finance world, where we deal with the taxation, be it income tax, be it the customs or the GST. Okay, what shall we construe as a heinous offense? It is essentially any any wrongdoing which has been done willfully. It is essentially and only that. If not willful, then all the legislations provide us an opportunity to correct ourselves. Right? Customs law, for example, Parth talked about the refund that Sony is claiming under Section 149, and there is another Section 154 of Customs Act, where if you have a problem, you filed an incorrect detail on the bill of entry while importing or on the shipping bill while exporting, you can actually get that corrected through the process of amendment. And the great part under customs amendment is that there is no timeline. So even after 3 years, 2 years, I am myself handling a case right now where for a huge technology company of the of the US, we do their periodic review, and this is the third year that we are reviewing. And during our review, we came across a lot of problems which we highlighted to the company, and then the company has taken our support to actually get those problems or the mistakes corrected. Okay, that was, I mean, simple. They had erred in the classification. While the duty impacts, I mean, whatever duty was payable, they are ready to pay. They have paid it in one of the ports, where we have been able to close the case. The cases are pending, for example, at Chennai port also, right? So the act actually provides us a lot of opportunity to correct our mistakes. But what about something where you know that this is a problem, okay, and you first of all you are still carrying on? That's one bit. And the second point is that you create a problem. You willfully create the problem. You say something wrong when you know that that that's wrong, or you hide information which is important and you have purposefully hidden, right? So in our kind of a field where for us, the finance and the tax professionals, okay, these are the issues which are actually heinous crimes. I mean, our malified intention. I mean, legally we call it mens rea sometimes, where your motive was incorrect. Okay, so it is the cases where there was a mens rea, there was a malified intention, are the cases, situations which account to the cognizable offenses. One more point here, for the cognizable offenses other than arrest and the personal penalty, is that in every legislation, every tax legislation that we deal with, there is a limitation of time. Okay, that authorities cannot travel beyond a particular time. Okay, but limitation of time does not apply in all cases of cognizable offenses. In all cases where you have willfully done something, you knew that this is problematic, but you have still carried on with it. Okay, so in those set of situations only you have this extended period invoked. Otherwise, there are plethora of judgments. We ourselves are contesting a couple of cases right now also, where we have we challenge that the extended period should not apply. I mean, one of the cases where, I mean, right now we talked of correction of classification, where we reviewed the operations of the company, and it was on behalf of the company itself. It was not the authorities that found out. We at the company itself found out that okay, there are some problems. We went ahead and made a declaration. The only point was that when we made the declaration, it was three and a half years period which was over, and by the time we made the declaration, there were 4 years which were over. When we sat into a discussion with the authority, they said that okay, so you have to pay back for last 5 years, right? And we resisted. We said that had we not come forward, okay, there was a high likelihood that you do not even come to realize that this is a problem which has happened. And therefore there is no case that you can say that we purposely misdeclared, or there was an intent, and therefore no extended period of limitation. And then authorities after a lot of resistance, when we had a discussion with the principal commissioner at the court, he agreed. He said that yeah, you guys have come forward yourself, so no extended period of limitation. Right. Now, what happens in case of a cognizable offenses? You get the imprisonment, and imprisonment is actually for more than 3 years. I mean, this is big deal, right? I mean, staying behind bar for 3 years, and like we just talked, for no error of yours sometimes. I mean, you don't know. I mean, the authority just came to your door saying that, hey, you evaded the duty. You have not paid the right set of duties, or the IGST, and you get into a problem. That becomes a cognizable offenses. Likewise, there is non-cognizable offenses where the punishment is lower, and rightly so, because non-cognizable are not such a big offenses. Right. But the important point here is that nowadays, or not nowadays, in fact, historically, the persons in charge, the important persons in the company, the management group, they have in past also been charged with the personal penalty, with jail terms. Okay. And of late, what we are witnessing, that with the exchange of information and all, the activities have picked up from on the part of the department, and the courts have started holding people more accountable, realizing that if it is a company, then it has got directly to do with the people. Okay. And not only on the part of the company. Very recently, I guess some 2 months back, there was a judgment of the Supreme Court, where the officer in charge was personally penalized, okay, for creating hassle. Okay. So there was an interpretation issue, and then officer, he interpreted something else, and then something else. So on one point, the department cannot have various views. Okay. Supreme Court took note of that, and he personally held the officer accountable, and I mean, the officer had to pay the personal penalty, the personal monetary penalty. So court mechanism is also becoming more and more robust. Okay. People are approaching courts. Okay. I mean, if there are problems, the departments have become more and more active. Okay. And therefore, we at the company, like the CFOs, the tax heads, we have to be vigilant about what is going on, what is not going on. Okay. And if there is something wrong, please take a note of it at the right moment. I mean, you cannot be waiting perpetually for it. Okay. For the department to come and surprise you. Okay. So we move to the next slide, Parth. Thank you. So some of the cases that we've highlighted here, and the objective behind listing down these cases are twofold. One was to emphasize that personal penalties, personal arrests do happen. I mean, you see, first of the cases, BPL Telecom, it's a known company, right? All of us know BPL before it got merged into Hutchison Whampoa and subsequently to Vodafone. Right. So the reputed companies, the small companies, okay, in all cases there have been arrests, there have been personal penalties. Okay. And this is what we wanted to highlight, that be careful. Okay. Now, second reason of putting these cases across to all of you were to discuss the common problems. Okay. The reasons as to why these sort of problems happen more often. Okay. And how can we actually safeguard ourselves, we can prepare ourselves not to get into this sort of troubles. First case, for example, if we see BPL Telecom, this was a misclassification of goods on import. So here in this case, the SSC, that is BPL Telecom, they misclassified the goods. I mean, misclassification, of course, is that you had to classify it under one heading, but you classified under something else. Now, in every case where we are talking of arrest, the personal penalty, it is only safe to assume very safe to assume that the offenses must be the cognizable ones. The offenses must be where the information were hid very purposefully. Okay, so in case of misclassification, the person was arrested. There was a penalty on him. Okay, so this was one case, and a very recurring one. We will just come to the next slide where we are talking about the classification at length and what is its importance and the relevance in the perspective of customs. Second was like violation of statutory post-import conditions, MB Patil construction case versus Commissioner of Customs. Here, I mean, just to let all of you know, I mean, I'm pretty sure you must be aware also. But what happens is that sometimes some of the imports, the authorities allow you the import with some conditions. Okay. One of the point I can say is that suppose what you imported required a license. You did not have the knowledge of that there is a requirement of a license. Okay, your goods landed at the port. So what you did in the good intention, you went to the commissioner of the port and you requested him that sir, we just missed it and we are in the process of making application. However, only because the goods are not being cleared and lying at the port, okay, this is, I mean, it is causing a lot of demerits to us. So kindly allow us a clearance with some condition that we do not sell or whatever. Okay. At times, what happens is that the commissioner grants you the NOC, and based on that NOC, you can actually clear the goods and put it into your own warehouse. Okay, but that the NOC comes with a rider. I mean, to my experience, if I can share, in 100% of the cases where there is an NOC from the commissioner of the port, he tells you that you can't sell the product into the market, because remember the importance of licenses sometimes is that is they want to safeguard. The licenses are there for a purpose, which we can talk in one of the next cases. But here the commissioner allowed you the clearance with a condition that you will not sell the goods into the market till the time you have obtained the license. Now what you do, you imported, you got it into your warehouse, you sold the goods. Now that is what is violation of statutory post-import condition. Okay, I mean, this is just one example I'm saying. I mean, there could be some specific notification driven post-import conditions also, and we as the importers, as the SSE, we have to be careful of these things. And if the conditions are violated, it has its own consequences directly in terms of arrests and the penalties that we're talking about here. Third case we're saying is a wrong availment of exemption notification. Okay, so here when you actually go and try to clear your goods, you have an option of selecting the notifications under which you want to claim the exemption. Now this is again a very important factor for all of us to realize and take note, that when you actually select the exemption notification, you have to know what that exemption is about. You have to interpret, because sometimes what happens is that for the same goods there are 2, 3, 4 different exemptions. I mean, one of the example that I can cite is when you import from, say, Thailand. Now India Thailand has a separate free trade agreement that Parth was talking about, the free trade agreement in earlier session. India Thailand has independent agreement also, and then Thailand is part of ASEAN nations, Association of Southeast Asian Nations, and then India has an agreement with ASEAN also. So if you're importing from Thailand, you have two options. Option 1 is that you can import under India-Thailand bilateral agreement, or you can import under India-ASEAN agreement. Okay, so and the example I'm giving is because when you actually select the exemption notifications, it's a possibility that there are multiple notifications that are available, and you have to be careful about choosing. You have to be knowledgeable about what are you trying to pick up, which exemption you're trying to claim. Okay. So here the third case that we're seeing here, the Kudos Kemi Limited versus Commissioner of Customs. It is a case where the importer claimed a wrong exemption. Okay, and because of the wrong exemption, the personal penalties and the arrest provisions get attracted. And only to reiterate, for the sake of reminder, is that in most of the cases that we're discussing here about the arrest and the penalty, they have to be cognizable in nature. Fourth case is import of restricted goods without license. So before I discuss about the consequences, let us first of all understand what is restricted goods. So there are three sort of classification of a product generally. I mean, based on the product category. So one is a free product where there is no requirement, nothing, you can just import. Second is a restricted item where you can import for sure, but you need to have the license. You need to have the licenses from the respective departments. For example, you're importing pharma product. So if you're importing pharma product, you have to have the license from the CDSCO, under the medical, from the FDA. If you're importing a medical device, the stent that you put in the heart, the calibrators. Okay, so if you are importing those, they are considered as a medical device, and you have to have the license which are prescribed under medical device rule to import that. Those sort of products are called restricted goods, where there is a restriction. You can of course import it, but after complying with some of the conditions which are there. And then the third is a prohibited goods, which you can't import. They are prohibited. So here the case that we're seeing here is Shivam International versus Commissioner of Customs. The importer imported the goods. The goods were restricted goods, but they did not take the license. Now this is crime, right? I mean, from customs standpoint, this is improper import. Now, let us go back, say 2 years back, 3 years back only, not far behind. The database or the systems of customs was not robust enough to capture or to understand the regulatory requirement, the PGA requirement, the partnering government agency requirement. Okay, so you as an importer, you filed and you imported, but frankly speaking, that product needed a license. Now customs system was not robust, so they did not catch hold of you, but you were aware. So what you have essentially done, you have willfully not obtained the import license. It's an illegal import. At the moment it is illegal import, it has its own consequences, and that is why the case is listed under this arrest and penalties heading. The last case that we have listed here for discussion was misdeclaration of value. I mean, absolutely needless to mention, when you compute the duty, two things are very, very crucial. One is the rate of duty, and second is the value on which the duty is calculated. The first case that you see, BPL Telecom misclassification, that must be for the rate of duty, because otherwise why will you misclassify? I mean, somebody will purposely misclassify only to claim a lower rate of duty. And this is a second case where you have misdeclared the value. By reducing the value, what is essentially happening is that you are paying duty on the lower value, which is not right. You must pay value on the fair price, that the import price. But if you have purposefully reduced the value while doing the importation and then paid the value, paid the duty on that reduced value, it is a crime. It is a wrongdoing, which is which is in fact nowadays the custom systems has become pretty robust to catch hold of these situations. But long back, this was not the case. Parth will move to the next slide. Okay, so while discussing this BPL case where we saw a misclassification, I said that we will be talking about it at length. Okay, first thing first is, and here I say again that one is the experience, second is the statistics, everything is available to say that classification is the most important aspect of customs, and in fact of GST as well. It was there in central excise also. So to indirect tax as a whole, classification is the most important aspect. An incorrect classification could lead you from point, if your destination was point A, incorrect classification leads you to point Z, or vice versa. So determining the right classification is very, very, very important. Very important. Okay. And remember, when we say that this is the most important aspect and all, this comes out of an objective. So when the World Customs Organization was devising this harmonized system of nomenclature, the HSN that all of us follow, all the signatory member of World Customs Organization follow this HSN, and India is one of the signatories. In fact, all the large trading nations that you can think of are the member of WCO, and they adhere to the HSN classification. The whole objective was that we put a common nomenclature to a product, a common code to a product, to identify for its identification at the international level, the identical identification. And second was that from a statistics point of view, also from a trade statistics point of view, the classification is very, very relevant. I mean, if government has to know that what is the volume of chocolates that have been exported out of India. Now, to tell you, chocolates get classified under Chapter 18 and Chapter 21 of the Customs Tariff Act, or even under GST. So for the government to know that what is the volume of chocolates which have been exported out of India, they have no information but to resort to what the classification is. One way is that they issue the notice to each and every manufacturer and say that, hey, let us know what is the amount that we have exported. And this is the easier way. I mean, this is a trusted way that you just go to the classification, filter out, and find the data. It is that crucial, and that is why when I said that it is the important aspect. It has its own reasons. Okay. Now, some of the points that we have highlighted in the presentation also is that first says that there are thousands of unique classification, thousands of HS code. I mean, HS code runs from Chapter 1 to Chapter 98, and 99 has been reserved for the services, where in the GST you would have seen that the classification for the services come under Chapter 99, including our chartered accountant services and all those. Right. So for the product classification, there is Chapter 1 to Chapter 98, and within that chapter also there are various headings, subheadings. Okay, and then the HS code, the 8-digit HS code that India follows. So if that's where the line is that for your one product there are thousands of HS code, and it is only one HS code which is applicable to your product. So remember the kind of diligence which needs to be there around the HS code. Humongous. And this can we can just see this here. Second, very important, and the reason behind the litigations or the investigations because of classification, and like I mentioned, more than half of the litigations, the investigations happen because of the classification. Okay, is the second bullet. The rate of duty, licensing requirement, and export controls are directly linked to classification. So suppose you had a particular classification, you classified your product wrongly under another classification, you're paying a different rate of duty. We have put in an example in the next slide, where it's a very interesting example that will explain you. But here, just to talk, the classification decides your rate of duty, the exemptions that you want to claim. Okay, the licensing requirement. Suppose your product was to be classified under 38, you classified under say 40 or 30, 31. The licensing requirement changes. One of the very good example that I can talk about on the licensing requirement is that you import a device and say that device works with a medical diagnosis equipment. Now, if you independently classify the device in say chapter 73, 74, or chapter 85, if it is something to do with a computer or so, there is no need of a licensing. But if you're classifying it under medical device, there could be a requirement of license, because the medical devices are regulated products. Not all where you need license, but medical devices per se are regulated products. So you may need a license. So the change in classification will have huge impact. Same is the case with export control. To those of you who are not aware about what the export control is, there is a set of products that our government, or not only our government, the governments across the globe want to regulate. These are the products of dual use, which can be used by the civilians in the business, in the household, and then can also be used for military purposes. The chemicals, some of the chemicals which are used in manufacturing of say bomb, or can be poisonous, can be used to kill someone, or arms, the aircrafts where which has that warfare facilities. Okay, so they are controlled product, and India we commonly name them as SCOMET product. Okay, so for that again the HS classification becomes very important, very important. And remember, these are the dual use goods. If you do not have the requisite license, and if you have exported, then you are directly defying the government's directives. The government's directive towards safety and security, the national security, and the penalties, the consequences are huge. Forget the cash penalty. Okay, you will have ED running behind you. You will have the NIA, which says that you are engaged in the criminal activity and all those. That is how important the export control is, and that is how important hence the classification is. It is directly determined from the classification. Third is which is common point, is that cost of erroneous classification can be staggering and could lead to delay in clearances of goods as well. How clearances of goods and classification, how are this correlated? This is directly correlated. That suppose you're importing something, you do not have one of the cases, for example, you do not have the license. Your product was never required to have the license, but unfortunately by mistake you wrongly classified the product. I have handled one such case in Mumbai port very recently, where my client, they themselves classified their product, where the new classification required a BIS license, while the originally the actual product which they're importing has no license requirement for the actual classification. But by the mistakes of the logistics team, the product required a BIS license. Now BIS they did not have, because the product originally never needed a BIS license. So what happened? The product was held in Mumbai customs for 2 years, 2 months. And after that also, the commissioner did not allow the clearance. He passed an order that goods are liable to be exported, and they also levied a penalty of 40 lakhs rupees, I guess. So that is how again important the classification is. And that's again, let's lead to our topic and ignore child of CFO, is that these are the cases where you need to have the interpretation. The people dealing day in and day out, like Parth also spoke, the logistics team, they are not supposed to be knowing all these nitty-gritties. They are not trained to know this. Most of them know this by virtue of their experience. But experience at what cost? Look at what has happened. They were not able to service their customer. They had to pay the heavy damages because the goods got stuck for 2 months at Bombay port. And finally, they had to re-export it and pay the penalty, heavy penalty. So this is what the consequences of the classification could be. Third is, another very important aspect, which we'll talk at length in the next example, the numerical example that I have provided in this slide, is that the HS code, when we talked about the countries adopting the World Customs Organization's HS classification, the WCO, World Customs Organization, specifies the requirement of a standardization of HS code till 6-digit level, 6 digits. In India, the HS code runs into 8-digit. For the countries like China and the US, the HS code runs into 10 digits. And the higher number of digits simply means more bifurcation of the detailed segregation of the products. Okay. So here 6-digit will stay standard across the globe, but last 2 digits vary from country to country. India can specify last 2 digits that China has not specified, or US has not specified. Europe has not specified. EU has only 6-digit requirement. But say Singapore, they are free to choose their last 2 digits of their own. And this leads to a lot of problem, which we'll show you in the next example on how important it becomes. And one of the points that we specifically also wanted to highlight is that for this last 2 digits, it's never fair to rely upon your customs house agent who are helping you in doing the clearance, because remember, yes, they are not the experts of law. I had a chance. I was doing the health check review of probably the largest chemical manufacturing company of the world. And while doing their risk assessment, I had a chance to interview the CHA. And when I asked the CHA as to how are you determining the classification, CHA simply says, I go and ask the uprising custom officers. Whatever he says, I put it. Now, initial 6-digit, it's a standard across the globe, understandable. But last 2 digits, he just checks with the custom officials, and whatever comes in, whatever is suggested by the custom officials, he put it. Now, if it is operating, you are not getting caught, you think that it's fair. I always give this example, that you driving on wrong side of the road and you are not meeting an accident, you can't say that driving on wrong side of road is fine because I have not met accident. Look, you have not met accident only because you are lucky. But driving on wrong side of the road is illegal, is punishable, and you are actually putting a lot of people under the risk. Same is the situation here. You say that you for last 2 digits you just relied upon what the CHA says. Now CHA is not a subject matter expert. He is an operational person, completely operational person. In fact, when we review the CHA agreements also while doing the health checks, I have never come across any CHA holding himself responsible for the classification. Technically, he can't, because he is not knowledgeable, he is not empowered that way. So relying upon the CHA is like a suicide. And let us see the example that we have presented in the next slide. Right. So here, I mean, this is one of the cases that we are dealing with right now. Okay. So if you remember, I just said that up to 6 digits, the classification across the world are uniform. Last 2-digit classification varies from country to country. Now we just saw how the companies rely upon the CHA for the last 2 digits, and look at the consequences now. So here we are talking about the diagnostic reagents. We're talking about the diagnostic reagents. So on the left hand side, I just reiterated the tariff here, is that the tariff description is diagnostic or lab reagents. Okay, on the backing of, and we don't need to read that much, but the description says diagnostic or laboratory reagents. Okay, now you come to the next 2 dash point that says for medical diagnosis. So for medical diagnosis, they have highlighted that if there is a pregnancy, if you're using the reagent for pregnancy confirmation, classification is 382200, which is same, and last 2 digit is 11. For diagnosis of AIDS, the last 2 digit is 12, and for other medical diagnosis, the last 2 digit is 19. And if not used for medical diagnosis, then the classification is 38220090. So there could be diagnostic reagent, but not used for medical diagnosis, who can also merit classification under 38220090. Now, as a matter of habit, what companies do because of the CHAs that we talked about, okay, is that they simply put everything in others. So when they import the lab, I mean, the diagnostic reagents for medical purposes also, they put it in others. Because the last classification that you see, 38220090, diagnostic reagents can also get covered into that. So they simply put others. Now, others has its own set of problems. Last year in January, February 2020, government came up with a requirement that anything that you're classifying in others, you can't do that. You either have to specifically pick up your classification, or if you're classifying in others, you report it to the DGFT. Such is the misuse of this others because of the lack of knowledge. Now come back to the consequence on the right hand side of the presentation. The consequence is that if you classify your product under 38220019, the basic customs duty, which is actually the cost, the basic customs duty is 10%. But if you classify your product under 38220090, the basic customs duty is 30%. So it's 10 versus 30, 3 times more, for a simple ignorance. Why I'm highlighting this basic customs duty? Because this is the cost. IGST, for the sake of argument, one can say that IGST is a creditable tax. So not much of a worry other than the working capital impact. But here, by virtue of you classifying a product which was actually a medical diagnosis reagent, instead of 19290, you are paying 20% additional duty cost. Huge. Initially, when Parth was talking about, I'll again take you back there, is that we saw how a 3% reduction leads to a 30% equivalent of income tax gain. Here you're talking of 20% increment in the duty rate. That is how important the last 2-digit classification also is. So we simply cannot rely upon the CHs. There has to be experts who review this classification. And here, you have to interpret, because it's a matter of interpretation. 38220090 is also not wrong. That only includes diagnosis reagents. So you have to be mindful of what you're picking. And here in the right side of the presentation, we have mentioned one bracket we're saying missed opportunity. So in GST, this 38220090, I mean 3822, the rate is defined for 3822, which reads as all diagnostic kits and reagents. Now, the authorities, the government authorities, the GST as well as customs, are taking the stand that it is all diagnostic kits and only the all diagnostic reagents that merits the rate of 12%. Other than that, if it is not a diagnostic reagent, the rate applicable will be 18%. However, there is a fitment committee report for the GST, and this fitment committee was the committee formed by various committees formed by the government of industry experts who recommended the GST rate while the GST rate was being decided in 2017. The fitment committee report suggests that the GST rate on all reagents, diagnostic as well as laboratory, all reagents are 12%. So the committee report suggests the reading as all diagnostic kits and all reagents, while the government officials are reading all diagnostic kits and all diagnostic reagents. And then there are favorable advance rulings as well, now which have come very recently. And not only the advance ruling, there is an appellate level advance ruling also. So there was an advance ruling which ruled that the laboratory reagent will be 18%. That decision was appealed, and then the Karnataka, the appellate authority for advance ruling in Karnataka, they upheld that this applies to all the reagents, the 12% rate. And they made a reference of this fitment committee report that I was just talking about. Okay. Now you see this technically, is that for a logistics person, he may not get into this sort of details because he is not trained to get into this sort of details. But we at chartered accountants, quite a few of us also have we try to read the law. We have extensive experience of reading the Income Tax Act, the GST Act, the Customs Act that while appearing for the CA exam, all of us have passed this indirect tax subject. Okay, so we have this habit, we have this practice of reading. We are trained to read that, and that is how it is important for us to get involved. The finance fraternity, the CA fraternity, the CFOs, the tax heads, to get involved in these things, okay, and understand the nitty-gritty, because you see the difference, 10 to 30%, which simply makes your procurement very, very expensive, very, very expensive. And procurement, reducing the procurement cost, procurement directly comes into the balance sheet. Procurement comes into the purview of CFO. So it's important that we start paying attention to this. The next slide, Parth. Yeah, another very, very important aspect that we want to stress upon, we want to highlight as to why this has to be looked in from an expert angle. Okay, so sometimes what happens is that that there is a very small issue. There is a the issue, if it is handled properly, could have been a cakewalk, because sometimes it's a settled principle of law. There was no sort of back and forth from the department also, because the law is clear on that. There are Supreme Court rulings, there are High Court rulings which absolutely says what the law is saying. Okay, so authorities had no scope of interpretation, nothing. But sometimes what we do is that we don't care for it. The small issues we choose to ignore. Okay, and that leads to a bigger problem. If those small issues are addressed at the inception stage by a right set of people, by the competent set of people, by the trained set of people that we're discussing, the issue would never become a big issue. And one of the live cases that we are seeing, and that's where I requested that we have this illustration before you, okay, only to highlight how and what we're talking, is that we're seeing a case where one of our clients paid duty on 75 times the value. They paid duty on 75 times the value, okay, and they at that time did not realize. I mean, it was a clerical mistake that the logistics team made, and they did not realize. Subsequently, when the finance team was also reviewing and they were going through it, they saw that there was a huge amount of duty which has been paid, the additional duty. Okay, now I repeat again that this was a clerical error which must have been handled at ease if the experts would have got involved at the earlier stage, which did not happen. And when a question was raised to the logistics team, they mentioned that yes, they have made an application for amendment, and in the amendment the assistant commissioner rejected the claim, saying that okay, there is a timeline, and you can't go beyond that timeline to make the amendment. Now, when Parth was talking about some of the refunds that we saw, the Sony case that he talked about, and the law also is very, very clear. Supreme Court judgment, Sony, ITC, where the courts are saying that there is no timeline for correction of the document. So they preferred an appeal before the commissioner. Now commissioner rejected it on saying that the appeal that has been filed after the timeline of the prescribed time of 60 days. And when commissioner asked for the reason, because he has the authority to condone for further 30 days, and the case was actually falling within 60 and 90 days, the SSC did not offer any explanation of why the delay in filing the appeal. And now the surprising part was that the representation was made by their CHA to the commissioner appeals, the CEO of their CHA. But then by virtue of his role also, he was not aware. He kept on insisting that no, there is no timeline for amendment. He was right, there was no timeline for amendment, but that applied when he made the application. Now this is an appellate authority. Well, you have filed the appeal. Now appeal has a timeline, and he did not explain. He did not understand what the commissioner was saying, and they simply got a rejection order from the commissioner saying that the issue is time bound, and there has been no explanation offered by the company. Now we are handling their matter at tribunal. What is important now again for us to realize is that it was a very simple matter, first of all. Second was that when the assistant commissioner rejected, okay, without citing the proper reason and all those, if we were involved at the right time, I would have suggested that you better file a writ petition, get the direction from the High Court, okay, and the writ petitions are fairly fast. Okay, so get the direction from the High Court, get the issue resolved then and there, which did not happen. So and now because we are appealing against the commissioner appeal order, where there is alternate remedy which is available, we can't go to the writ court. We can't file a writ petition now, and we will have to rely to this SISTAT. Another problem is that this is the amount involved was huge. The SISTAT listing will happen only in 2 years, I guess, based on the experience. If this was a less than 50 lakh matter, single member judge, you get it a little bit faster, but otherwise it will happen in 2 years is the minimum, I'm guessing. Okay, so you understand the point. The refund that you should have received actually within say 3, 4, 5, 6 months is the upper cap. So the refund that we should have received within 6 months has been perpetually prolonged. I have written here that the 6 months becomes 6 years. Okay, but it may or may not happen in 6 years. I mean, it can happen sooner also. But you understand the problem. It was a settled principle of law, and for a settled principle of law also, since it was not handled by the right set of people, the 6 months goes into a 6 years. Huge amount, directly impacts your cash flow, sitting with the government. Simple issue for non-competence. Therefore, very, very important again, that right set of people look at, and I keep repeating after every slide that we are the right set of people to interpret that. We, the chartered accountants, because we deal with that in income tax, we deal with that in GST day in and day out. So we are the right set of people to handle this. The logistics people do not understand the magnitude of a simple change, of a very simple, because they don't know. Right? So time for us to intervene in then these issues also to make it only better and do better for the company. We move to the next slide. Yes, this I have picked it up very purposefully to highlight that nowadays what is happening is that nowadays the data sharing is pretty fast, but previously also there was an exchange of information between customs department and the income tax department. Now, I mean, you can see this report of a financial newspaper where it is mentioned that customs and IT departments work closer to vet MNC transfer pricing. Before we get into what the issue is or how it gets dealt, let us first of all admit that transfer pricing in any of the organization is essentially dealt by tax under the CFO, by the chartered accountants. Now, SVB, there is one special valuation branch of customs. The SVB is nothing but transfer pricing under Customs Act. So here, if you're importing from the related party, okay, there is a probability that since you're importing from the related party, you import at the lower price, you pay the lesser duty, and the customs, the government is very right in thinking that, and therefore there is a prescribed mechanism under customs where they are saying that the import transaction has to be done at the arm's length, same arm's length that we are talking in transfer pricing of income tax. Now, what happens is that, and that is where I like to quote. I'm not sure if you all can read, but we have highlighted in this, we have put in the red line that we have mentioned. There is one executive from multinational firm who is giving the statement saying that most of the times the issue happens because the customs valuation is handled by the logistics team and transfer pricing is handled by the finance team. Finance and logistics, by virtue of their setup, they don't talk to each other on a regular basis because logistics is more to do with the operations, finance is post operations. Okay, so by virtue of the organization setup and their roles and responsibilities, they don't talk to each other on a regular basis. Now, what has happened? Under the income tax transfer pricing, you agreed on a particular profit margin, and that particular profit margin is not corroborating with the profit margin or the margin that you're showing under the Customs Act, Customs Transfer Pricing, SVB, Special Valuation Branch. There is a direct trouble that you're creating for yourself, direct trouble. And now with auto exchange of information, with everything being online, the information exchange is on the tip of the finger. So you file a transfer pricing, APA, advanced transfer pricing study, or any other transfer pricing study report, and at the same time you do your SVB. If the authorities immediately look at it, and the income tax authorities also take a note of what you have filed under the customs transfer pricing, and if there is a difference, you get a notice either from the income tax or from the customs. Okay. And therefore it is very, very important that the transfer price that is discussed, that is presented before the authorities, are in sync. The income tax transfer price and the custom transfer price, they should be talking to each other. They should not be like, you filed something here, you filed something there, which happens, and which happens with large companies. I can't tell the name of the companies, of course, but some of the multi-billion-dollar companies, $50 billion, $40 billion companies that we're handling, okay, these sort of problems happen. Therefore, it is very, very, very crucial that what we are submitting there in income tax is same as what we are submitting under the customs. There is exchange of information which is happening. Please, all of us, let us note about it. Okay, and let's be careful, and while dealing, let us again ensure that it is dealt in an expert way. Yeah. Another on the sharing of information. Very, very important that I thought these are very, very important. Why? Because we are handling a lot of cases around it, and the cases have essentially originated because of this exchange of information. So first, I'd like to talk about GST department and the customs department exchange of information. Now, this should not look like a big deal because all of us, the tax professionals, are filing the GST return for our company or for our clients who are practicing. And there is this GSTR 2A that you get about the report of input tax credit, and in the GSTR 2A you get the credit number of the goods that you've imported and the IGST that you paid on importation. So that directly flows from the ICAI system that customs use to your system of GSTR 2A. So there is no surprise that there is exchange of information, and there is also no surprise that the exchange of information is on a real-time basis. It is happening live, that once the data is punched in ICAI, accepted by the customs, you made payment of the duty, the details get remitted to your GSTR 2A. So it is live information which is being exchanged. So what is the point of worry? What I'm trying to refer here. So the point that we're trying to hear is that since there is an exchange of information, there is a steady going of the returns that you're filing under the GST and what you have done under the customs. Now, one of the live cases that we are dealing with, what is happening is that our client, say they are importing something at rupees 100. The sale price of what they're importing it at 100 is actually Indian rupees 500 in Indian market. So import price is rupees 100. The sale price in Indian market is 500. Huge profit margin, 400%. How did custom pick this up? Custom picked it up from the GSTR 1 filed by the customer, the client that I'm referring to. So they reviewed the customs department reviewed the GSTR 1 of the client, and then they sent a notice to the client saying that what you're importing at 100, you are selling in the Indian market for 500. Can there be such a huge margin when you are doing a B2B transaction? Business to customer transaction, it is still understandable. I mean, it's still very, very huge, but you still accept. But for a B2B transaction where business you imported and you're selling to the business houses, can there be a 500% margin? Can there be a 400% margin? Okay, and this was directly questioned by the customs, and the investigation is still going on. The finance controller was picked up. I mean, DRI came to their office. The finance controller was picked up. 3 days of examination happened of the laptops, every system, every email exchange, because the customs point was that since you are importing from the related party, there is a possibility that you have imported at the lower price. You should actually have been importing at say 300, but you imported at 100 purposely to evade the customs duty payment. So the investigation is going on. Okay, but point we're trying to highlight is that this exchange of information is happening on a real-time basis, and because of which lot of notices are coming, issues are happening. Therefore, again, what we are doing in the GST return has direct implication on the customs, and hence talking to each other. One probably one team doing this also and that also, GST and customs, will make it easier for team to understand the problems, the magnitude of the difficulties that they may get into. Now, the point that we talked about, the sharing of information between GST and customs, is not very surprising, because both of them are the part of indirect tax, CBIC, dealt under the Ministry of Finance. What is very surprising, which is there on the right hand side of the slide, is exchange of information between overseas customs and Indian customs. This is creating a lot of problems of late for a lot of MNC companies, where what happens, by virtue of mutual agreement, the government signs a lot of agreements with other nations to share and exchange the information. Okay, and the exchange of information, the share is to ensure that there is a building of trust that happens between two nations. You build a trade relationship, non-trade kind of, where you trying to build an employment relationship. You want to create a market for yourself there. Okay, so because of these sort of objectives, the two nations sign agreement. Under that agreement, okay, there is sharing of information clause as well. Now, in the very recent case that I'm currently handling is where my client, it's a US based multinational. They imported something, or they import something, that's what they trade in. For that product, they have started, the US customs has started a question on them in the US for that product, and the question is not public, because remember, if there is a ruling, if there is a decision which happens in the US, in the UK, or in the EU, you can find out. That becomes a public information, and you can actually get those rulings, get those reports. But this is not a ruling. This is only initiation of an inquiry, which is supposed to be confidential. So for the question which was raised to the client in the US, identical notice they received here in India, mirror image. So when we started interacting, we asked about where is it coming from and what's the problem. Then they said that they have received a same notice in the US, and to make it merrier, they have received the same notice in the EU. They have office in Belgium also, so they received the notice in the US, in the EU, and in India, identical, same issue. So there is that level of exchange of information which is going on. Therefore, whatever filing that we're doing, we have to be extremely careful of what we're presenting to the government. Okay, and this is not merely operational aspect. This has to be reviewed by the expert. The decision that you now take, okay, has global impact. So it has to be reviewed in that perspective, and that's where the importance of paying attention to or getting the attention of the right set of people within the organization. We'll move to the next slide. Yeah. So this is another point which I wanted to highlight, is that a lot of points that we have right now talked about say receiving a notice for valuation, for HS code, exchange of information. What is happening is that because of the availability of information, the customs department has also become very active, very active. So there is this audit department which is there in all the department, and by virtue of customs, to those of you who do not know, customs is a self-assessment process where you file, when you import and you file the bill of entry, It is the declaration that you are making, and government is not checking each and everything. So there is a post clearance audit which happens, and there is an audit department which does that. In last 1 year, I can tell you is that we are handling the client where I'm at least handling 40 cases where the clients have received this audit consultative letters, where the audit department of customs, they review your import history. How are you declaring it in other nation? What is happening here? Okay, or in India itself, you were classifying under say HS code 1 few years back, or few months back. Now you are declaring it under HS code 2. Okay, so these things are being noted with the help of system, and the clients are getting notices after notices for audit initiation. There is inquiry, and once this happens, okay, you are, of course, you fall into the litigation thing. Okay, so what is the requirement? Can we stop these notices? We can't stop the notices. No, we can't. But what can we stop is that we can handle it better by having the preparedness, by paying attention, by thinking about what is there and what is not there. And just to step back, I said that can you stop this? Possibly yes. I mean, not really that you can't. Possibly yes. Why? Because if you have followed the procedures well, if you have complied with the law and the regulations, okay, then there is a high chance that you do not receive these notices at all. So it is time that you pay attention to how these situations come in. How are you arriving to your classification? What kind of notifications are being picked up? What is the interpretation that we're doing to a particular point? And then come to a conclusion. And that conclusion has to be consistent within the company, across the ports. I mean, for our clients, very large MNCs, again, I talk about, okay, is that, they, for the same product, they are adopting one classification in Chennai, they are adopting another classification in Mumbai. In Delhi, they are adopting the third classification. This is, again, they are creating problem for themselves, because to the logistics person of that location, he is only concerned about clearance from that location. But from a company standpoint, bill of entry is filed basis the IEC, importer exporter code. So for one company, you have one PAN and you have one IEC. So from a job KRA point of view, the logistics guy of Chennai has done his job, the logistics guy of Delhi has done his job. But from a company point of view, they have created the problem. Different HS codes adopted. Wrong. You're inviting the trouble. Now, this is what he will not understand, because his job is to make the clearance faster. His job is to deliver the goods on time. He is not bothered about what is the consequence of change in classification, or whatever he is doing. Hence the need for a uniform approach, stronger internal policies to take care of this sort of situations. But we move to the next slide. Yeah, DRI investigation that I was just talking about. So DRI is the intelligence wing of CBIC. Directorate of Revenue Intelligence is what it is called. And they have real-time information available because of the digitization and the data sharing which is happening. And what I can tell you is that they are not the nicest of the department. So we meet day in and day out. I mean, we meet the GST offices, we meet the custom offices, we meet the income tax offices. The officers that we meet are, I mean, from the assessment department, are very, very different from the audit department, from the appellate department. They have a different approach, while the DRI has a very, very different approach. Most of the time, they have some sort of an intelligence that you are doing something wrong, and 20% of the time the information that they have is right on face, right ab initio. 80% of the time, there is a research review and the discussions which happen, but 20% of the time they do have just accurate information. So they are not the nicest of the people. They'll threaten you. They'll try to. Their objective is to extract the money out of you, get you to agree and pay the duty. Right. So the way you deal with them, and it's frustrating. You just don't want to be appearing before them. Right. Now, why do these DRI investigations happen? Largest cause is when the DRI has reasons, two reasons. One is that you are importing something illegally, or second is when you are doing a duty evasion. These are the two reasons where DRI get very, very active, very, very active. Okay. And if they get active, you get into trouble. Okay. So how do we tackle this sort of situation? So in point number 6, I mentioned that we conduct a periodic review of our transactions, probably once a year or once every 2 years, whatever the case be. Tighten the loose ends, okay, to ensure that what we are doing is within four corners of law, well reviewed, in the knowledge of the people, of the right set of people. And if there is any consultative requirement which is there, which is not there, okay, that has to be seen. Having said this, I come to the end of presentation, but the objective was twofold objectives were there. One, that we wanted to highlight that the CFOs, the legal heads, the relevant professionals who are capable of actually interpreting things up, making a sound decision, should directly get involved into customs. It's time that we do that. Okay, because long back there was everything was manual, and what you import, it stays there. I mean, the documents that you file, it stays there with the customs. There is nobody who is looking after it. But now the information exchange is real time. Everything, in fact, the filing has started happening online. The bill of entry that you file is also has started happening online. So information exchange is real time. The notices are coming. The companies are being reviewed. Okay, and any sort of discrepancy is resulting into a very painful sort of an end. Right. So right attention of people is needed. And second, more important, I wanted to talk about at this forum is that there is a shortage of professionals also. Parth had also mentioned during his session is that the CHAs act as quasi advisors. Now, CHAs can't be the advisors. But here again, I mean, we the CAs have also not picked it up with the intensity that we are dealing the GST or we are dealing the income tax. We are not dealing with the same intensity here. Okay, so there is a dearth of the expert professionals as well. There is either a CHA or there is a law firm. CHA is there for day-to-day problems that happen, and the law firm comes into play when the litigations happen. There is nobody to tackle in between. So I just wanted to highlight, because I am talking to the CAs here. Okay, so important that we get involved here. Thanks a lot. Any questions that you have? I'm very happy.
Yeah, thank you, sir, for the nice presentation. And I want to make one small announcement. Those who want to ask question can unmute and ask, so that the speaker can identify the person and answer properly. And I will give you a small example. Say, for example, I will take strong coffee, sugar. Then it is 99.01. Then the coffee with more sugar is 99.02. Likewise, you are having 98 commodities in one entry. Therefore, be doubly cautious about the HSN classification under GST, under customs, under income tax act, so that you can avoid many issues because of this. So I request the audience to ask question by unmuting them.
Sir, sorry to interrupt. So the thing is that since it's a webinar pattern, they might not have the option to unmute themselves on this platform. I have compiled whatever question. We have 3 to 4 questions compiled it up. Is my screen visible, sir?
You can give the question.
deferment is not available for T1 AEO holders. I
No,
think the
deferment.
question goes to
Duty deferment is not available for AU tier 1. It is only for tier 2 and tier 3 status holders.
and the of ROSCTL and duty drawback be claimed simultaneously.
Yes.
Could you please explain in the FTWZ whether an overseas manufacturer, say from Europe, would like to bring their high value machinery in India? They get identified any end customer. In this case, whether overseas manufacturer who does not have any GST PAN in India bring the goods under the FTWZ scheme.
Yes.
They can bring.
Yeah.
Then they
Okay.
will.
Yes,
go ahead.
actually, yeah, they can actually bring the goods into FTWZ. So what law mentions, and see, FTWZ is more like a transshipment arrangement. So when goods are moving from custom port to FTWZ, there is a certain kind of inbound bill of entry that is required to be filed. Now, what normally happens is that when we are filing this bill of entry, we are required to declare who is the importer on record for the purpose of this bill of entry. Now, if a person has a PAN number and if he's engaged in the activity of import and export, he would be having a import export code, that is IEC also. In that case, he becomes the importer on record. However, as mentioned in this particular example, if it's an overseas company who doesn't have any operation in India, doesn't have any PAN, they will not be having a IIC. In that case, a person who is responsible for getting the goods cleared, it could be his agent or his logistic partner, then IEC becomes
Or simply the warehouse operator.
or the warehouse operator. They would become the importer on record, and using their IEC, the goods will be cleared and allowed to be stored in the warehouse.
They will also would like to participate in various industrial exhibitions, etc. In such case, whether the customs permit them to take out the goods from FTWZ, it back.
Yes, there is a mechanism where you can get the goods for exhibitions. But like Parth also mentioned, every goods that you clear within our territory of India, okay, there has to be an IEC on which you clear. Okay, so the IEC you can use of the logistics service provider or anybody, but this arrangement is actually allow where you can participate in the exhibitions and then take the goods back.
If the machinery remain unsold, they also would like to take it back to their country. How the FTWZ is beneficial in these circumstances? Goods on FTWZ will be really helpful.
Right. So first thing first, I'll like to link this point C to point B, I guess, because point B you're talking about bringing the goods into exhibition. Okay, so in point C, I will assume that you are thinking that what if the goods get sold in the exhibition itself, right? So if you are selling the goods, that the different set of regulations will apply. Can you do that? The answer is that yes, you can still do that. Okay, but the regulations will be different. And third is that if the goods are not sold, you can take it back. Of course, you can take it back because the goods that you clear for exhibition comes under a different set of approvals. Okay, and we call it ATA Carnet sometimes. Okay, so it comes under different set of approvals. But yes, all three things are allowed. Point number A, point number B, and point number C.
When the import, when we import capital goods under MOOWR scheme, as the liability for customs duty exists till the machine is disposed of. Supposing we scrap the capital goods after 25 years, do we have to pay full duty at the time of scrapping after 25 years?
Parth, you would like to answer?
Yeah. So what the scheme actually suggesting is that you can clear the goods from from the manufacturing warehouse to DTA on payment of customs duty. And what is envisaged is that the goods that you're clearing are the goods which are manufactured in this particular warehouse. Now, in this particular example, if it is a capital goods which is being imported, of course, it will not be directly manufactured, but it would be used for the purpose of manufacturing. To the best of my knowledge, in the scheme itself, they have not envisaged this particular scenario. But if it's being sold as a scrap, then it doesn't seem that there should be any custom duty liability, because there would be enough justification to say that why custom should not be levied. Of course, there will be a GST liability on the value of scrap that would be levied.
Import of capital machinery under bonded warehouse, MOOWR, thereafter sale at scrap value, duty to be paid at import sale value, whether depreciation is available.
Sale value.
Sale value.
Sale. Yeah.
Under GST also you will have to pay on the scrap value.
Yeah.
Can be manufactured, can be take place in FTWZ.
No, so FTWZ is supposed to be a trading and warehousing zone. It is not supposed to be a manufacturing zone. So manufacturing can't happen, but there are certain small processes like packing, repacking, labeling, relabeling, which can happen in FTWZ.
So I thank two speakers who were very young and have explained the details in a very nice manner. I thank the chairman of SIRC, Mr. Chalapati sir, and secretary of SIRC, and I thank all the members who attended the issue. Thank you very much. We will meet in the next session. Thank you.
Thanks
Thank
a
you
lot.
so much. Thank you.
Everyone.
Thank you.
Bye.